Good morning to everyone. And first, I want to thank the organizers of this conference for inviting me. It is really an honor to be able to participate and present my topic today, which is, as you can see on the screen, the voice of the child in Croatian courts between legal norms and judicial practice. And the aim of this presentation is to try to answer the question whether the relevant legal norms are adequately represented in practice in Croatia. And I want to do that first by briefly explaining or presenting the Croatian legislative framework on child participation in courts, and afterwards by presenting you some challenges in practice. So to start with, Croatia has a legislative framework that protects the rights of the child, including the child's right to participate in court proceedings. And this framework is shaped by the Constitution, international conventions, and several national statutes, all of which work together to safeguard the child's well-being and access to justice. At the constitutional level, children's rights fall under the broader category of human rights. So although the Constitution does not explicitly mention the child's right to participate in court proceedings, this right is protected. The most important provision is Article 29, which guarantees that everyone, including children, have the right to a fair trial before an independent court within a reasonable time. And this forms the constitutional basis for access to justice, also for minors. International instruments also have a crucial role. Under the Constitution, international treaties that Croatia has ratified form part of the internal legal order and are placed above national statutes. And in that vein, Croatia is a party to the UN Convention on the Rights of the Child, the European Convention on Human Rights, and the European Convention on the Exercise of Children's Rights, among others. At the level of statutes, the most important one is the Family Act. It incorporates principles from international law and covers all matters affecting children. For example, parent-child relation, adoption, guardianship, and so on. And in terms of child-friendly justice and procedural rights, the key provision is Article 5, which obliges courts and all competent authorities to protect the child's rights and well-being in every procedure. The Family Act provides detailed rules on both representation and participation. Since children usually lack litigation capacity, they are represented by parents, guardians, or when there is a conflict of interest, by a special guardian. And special guardians play an increasingly important role, although their effectiveness may be limited by heavy caseloads or logistical challenges. Croatian law also recognizes some situations where minors can act more independently. For example, a child aged 14 or older may request permission to independently present facts, propose evidence, or even initiate proceedings, if they are capable of understanding the meaning and consequences of their own actions. Beyond representation, this framework strongly protects the child's right to be heard, while the Civil Procedure Act only briefly mentions hearing children. The Family Act provides more detailed rules. So children must be informed about the key elements of the case. They must be advised appropriately and allowed to express their opinion. The method for hearing the child is regulated by a specific ordinance, which emphasizes preparation, assessing the child's maturity, and obtaining their views in a supportive and safe environment. In criminal proceedings, the general rules on child participation will apply accordingly. So children will be able to participate in criminal court proceedings through representation, but will also be allowed to express their views and testify where needed. Due to particularly sensitive issues of criminal law, The Croatian Criminal Procedure Act and Juvenile Courts Act regulate matters of the child's participation in criminal proceedings in more detail. And the regulatory framework on children's participation in criminal proceedings will differ depending on their role in the proceedings. So whether the child is a victim of a criminal offense, an injured party, a witness, or perhaps a perpetrator. So overall, Croatia's legislative framework provides guarantees for child's participation in court proceedings through representation, the right to be heard, and procedural safeguards. So the challenge lies not in the wording of the laws, but in ensuring their full implementation in practice. And the question that arises is whether these legal norms are adequately reflected in practice. And I will try to find an answer to this question by looking at reports of the Croatian Ombudsman for Children and also some available case law. Starting with the reports of the Ombudsman for Children, specifically the reports from the last 5 years, I focused on the findings relevant to the central theme of this presentation, so the voice of the child in Croatian courts. And on the slide, you can see the challenges that were highlighted in these reports. So one of the main problems that the report identifies is the fragmented system of child representation. Children often receive different special guardians in different proceedings, which means they have to repeat their story multiple times. And this may confuse and tire the child, but it may also fragment their voice across multiple professionals. Another issue, which is a general issue in Croatia, is the slowness of court proceedings. So delays may happen both in civil and criminal cases, hearings may be postponed, and some procedures can drag on for years. The Ombudsman report also points out that many courts and police stations still lack child-friendly environments. In some courts, there is only one entrance, so a child victim may meet the alleged offender in the hallway. Some buildings are actually located right next to prisons, so children may see bars and people in handcuffs. And it is, of course, difficult for children to speak freely and confidently in such an environment. We also see cases of inappropriate or even coercive practices toward child suspects. For example, there was one example given in the report where a child was being interrogated for hours without water and being threatened with detention if they don't confess. So these practices directly contradict some minimum procedural guarantees for children and undermine the trust in the justice system. The report also emphasizes the lack of proper communication. Children and parents often do not receive clear information about their rights, about the procedure, or about what will happen in court. Sometimes parents are even misinformed. For example, being told that the child can be forcibly brought to court when that is not the case. And finally, access to court is still difficult in some regions. Family departments of courts may be far from where the child lives, which creates some financial and logistical barriers. Of course, the reports also note positive developments. For example, the 2024 amendments to the Courts Act introduced specialized requirements for judges working on domestic violence cases. So courts must now designate judges and court staff who have a strong interest in this area, and these judges are required to undergo regular professional training. And this reform supports higher levels of specialization and competence, which is essential for creating a justice system that can better understand the child's voice. So when we look at all these findings together, we can see a certain discrepancy between legal norms and judicial realities. In terms of case law, I looked at publicly available Croatian court decisions involving children, mainly civil cases and some criminal. And the main point that I have seen when reading the decisions is, First, that the best interest of the child does in principle always guide court decisions. The judgments always highlight this important principle. However, it seems that sometimes this best interest of the child is stated with no further explanation on how the best interest of the child in that particular case was assessed. And this connects to the second main point that is visible from the case law, and that is that elaborations in court decisions are not always transparent. It may be stated that, yes, the child's best interest must be taken into account, but it is not further elaborated upon. Finally, some court decisions, for example, the one from the misdemeanor court in Zagreb, explain in detail how the child's opinion was taken into account and how it was taken and assessed, while in some other decisions, it is simply stated that the child's opinion was taken without additional elaboration. So there is an element of inconsistency among the decisions. So to conclude, I think we can notice certain challenges in the Croatian context, at least. These include fragmented regulation, slowness of proceedings, uneven court infrastructure, also overburdened social welfare centers, inconsistent judicial attitudes, limited training of practitioners, and non-transparent and inconsistent judgments. Of course, some of these issues are a bit harder to solve or improve upon, but some potential recommendations that I can list are adopting a unified protocol on hearing children across all proceedings and actually enforcing it properly, mandatory training for practitioners, establishing child-friendly rooms in all courts. Obviously, this requires some investments, but it is extremely important for the well-being of children. And perhaps the possibility of periodic independent evaluations to assess the quality of child participation. I don't want to end on a negative note, so I just want to highlight that there are many positive developments in practice regarding the voice of the child in court proceedings. These are only some of the challenges I discussed, and they do not arise in all or the majority of cases. But there is always a space for improvement, and I think it's important to go step by step in improving children's rights in courts. Thank you very much for your attention.